May it please, Your Lordship.
Yes.
In item number 16, my lord, I filed an affidavit in reply today. I may be allowed to bring the same on record, my lord.
16.
16, my lord.
What?
I filed an affidavit in reply today, my lord.
Hmm.
I may be allowed to bring the same on record, my lord.
Lordship, Lordship, I am appearing on behalf of B. Taba.
Hmm.
For item number 8.
Hmm. What do you want?
Matter may be kindly adjourned for today, Your Lordship.
On the prayer of so-and-so, learned counsel appearing on behalf of Mr. B. Taba, learned counsel for the president, list this matter after 4 weeks.
Deeply obliged.
Lordship, mention item 11 on behalf of Mr. K.F.
Hmm?
Nibang. Lordship, I beg for adjournment.
Hmm. So-and-so. After 3 weeks.
Obliged. Your Lordship, on behalf of
Item
item number 28,
28. Yes.
would like to adjourn your Lordship.
Hmm. Adjourn.
Obliged.
My lord, I beg to mention item number 32.
Hmm.
The leading counsel for the petitioner is out of station.
Who?
Dikki Pangan.
It's 2018 matter.
Lordship, I'm for the petitioner. Lordship, what happened in this case is the writ petition was disposed of.
32.
Yes.
32.
32.
32.
The writ petition filed by them was earlier disposed of. Later on, appeal was filed,
Hmm.
writ appeal. Then thereafter, a review petition was filed. The review was allowed, and therefore this matter is to be heard again.
Okay.
Now, while passing the review order, the honorable reviewing judge has allowed me to file some additional documents which I had filed, and they had to reply to the same. Now it's been almost third or fourth occasion now that they have not filed it.
Hmm.
So that may be recorded in the order.
We will dispose of the matter. What's the matter is very simple. According to them, he scored. He or she.
No,
she scored
Lordship,
higher
they were,
marks than you,
yes,
but then you have been appointed.
Lordship, they were allowed to file a reply to that, Lordship.
Mhm.
Since Mr. Panging is not here today, I
Can
would
you show any document saying that, showing that, which shows that you have scored more marks than the petitioner?
that is on the records itself.
It's higher.
Yes, I don't think they have the original records as of now. But it is in the record itself.
Then we, in that case, we'll call for the original report. Your stand is that you scored higher marks.
No, it was their stand. It was their
What about
stand.
you?
My
What is
stand,
your stand?
my stand is that as per the merit list, I was allowed. I was selected. Later on, they filed some RTI and claimed that their marks is higher, substantially higher. Then, on the basis of that,
Yours is 282 something, 292.
no, Lordship, 212.
212.
Yes, including the Viva marks 232. Now, Lordship, their claim is 282. It was their claim in the
They
first
claim
proceeding.
that they scored 298 something.
Yes. Then, without calling for the records, this honorable court had allowed the writ petition. Later on, by filing RTI, it was found that the original mark answer sheets only of the petitioner and not the rest of the candidates was absent. The basis on which the RTI was given, that itself was not there. So that is why the review was allowed. So therefore, we have brought those documents on record, and they were
Showing that you scored higher marks.
no, showing that the basis of their claim itself was absent. They have claimed on the basis of an RTI. Now there was a committee formed. The person who had given the RTI himself claimed that he did not see the original. So there is no question of certified copy.
But what is your state, what is the exact position about the marks?
About the marks, as per the earlier recruitment process, I was the selected candidate.
No, that is no doubt.
Yes.
But how much score, whatever the score?
I am not budging on the score. Whatever score I was given, as per that,
Do you admit that the score they projected about you?
yes,
Which you have scored?
yes, that is true.
It's true.
That is true.
Better is there. Just because you have been appointed, it cannot be.
No, Lordship. Their claim is based on.
Anyway, since he's
Yes.
we'll see. You produce the record, we'll see. If you are admitting, a record is also not required.
Lordship, their claim is on the basis of an RTI document,
Okay.
which says that they have scored higher, which is different from the earlier results.
Okay.
That is why, Lordship. Suppose they've scored 10 earlier, I have scored 15, I was selected. They filed an RTI saying that my actual marks is not 10, but it is 20.
Okay.
Yes, that's why.
So according to your record will be required.
Yes, Lordship.
Where's the record?
I think I haven't checked because last time the records was full also it was really available. I think it's in office.
If you have in the office, you will produce next. When do you want?
After vacation, my lord, immediately after vacation.
Who is working?
Lordship. They are
Still-
working on the basis of that
Okay.
earlier writ petition.
You have been
Yes,
removed.
I have been removed.
See, I told you are
Because
still-
next time they come, I'm asking Lordship to record this because next time they come, they'll again say we'll need to file reply. That is why.
So before the next date, if they want to file, will record.
Yes, that may be recorded, Lordship.
On the prayer, on the ground that Mr. Deepangi learned counsel for the petitioner has some personal difficulty today, Mr. Swen's learned counsel for the learned counsel press for adjournment of the matter. Please do. MS and again learned counsel for the respondent, sub-respondent submits that she has filed an
Additional affidavit.
affidavits bringing on records the documents as directed by this, as allowed by this court, to which the petitioner is yet to respond. Therefore, if they want to, if they wish to file the response, if they wish to file counter to the additional affidavit, a last chance may be provided to them. Please do. Next prayer. Considering that Mr. Deepangi has some personal difficulty, the prayer for adjournment is allowed. Please do. The petitioner may file the response to the additional affidavit filed by the private respondent on or before the next date of listing. Mr. Estafet Learned, Senior Government Advocate, is also directed to produce the report. List after 3 weeks.
Obliged.
3 weeks.
List after vacation, Lordship.
3 weeks.
Yes. Okay.
My lord, I have another mention, item number 9.
9.
Yes.
Okay. On the prayer of so-and-so, learned counsel for the petition. List this matter after 4 weeks. 4 weeks.
After 3 weeks, my lord.
3 weeks.
All right.
My Lordship. Lordship, I beg to mention item number 6.
Hmm.
Your Lordship, this matter was supposed to taken up today by Mr. K. Lawyer.
Hmm.
However, due to some personal difficulties, he could not attend. So the matter may be listed after 3 weeks.
On the prayer of so-and-so, learned counsel appearing on behalf of Mr. K. Lawyer, learned counsel for the list this matter before any other appropriate bench without me. I'll not
Okay.
take up. I cannot take up.
Please, Your Lordship.
Yes.
Lordship, I would like to mention item number 17.
Hmm.
This is a case of 2020.
Hmm?
In the meantime, the petitioner has also got retired, Your Lordship.
Hmm.
So I would like to inform him, and this matter may be fixed on next date for hearing, Your Lordship.
Huh?
Your Lordship, this
You
is
want sometime?
yes, Your Lordship. I need some because
Uh,
already petitioner have retired, Your
On
Lordship.
the prayer of Mr. A. Bhattacharya, Land Council for the petitioner. Matter is adjourned for 3 weeks. So as to enable him to obtain instruction.
Much obliged, sir.
May I, Your Lordship, I beg to mention item number 30 and 31. I'm appearing on behalf of N. Pada petitioner.
What is this? 2017 matter. What is the problem?
Your Lordship, due to some personal difficulties, is not.
What personal difficulty? Listed for hearing 2017 matter. Anyway, on the ground that Mr. N. Pada, Land Council for the petitioner, has some personal difficulty today. Mr. So-and-so press for adjournment of the matter. Prayer not being objected to by senior government advocate. Come on. Same is allowed. List after. Is there any interim order? List after 6 weeks. It is made clear, please, it is made clear, no
Much
further
obliged.
adjournment shall be granted on the next date. Hmm? Interim order,
In item number 30.
then make it 3 weeks.
Obliged.
Your Lordship, may I mention item number 7? I need to file rejoinder.
Hmm. On the prayer of Mr. 7,
7.
D.K. Deori, Learned Council for the. No, this is something, your name has not been included.
No, this is a repetition I filed for to send the reference. My application is pending before the deputy
So
commissioner.
we'll direct them what's there.
In that case,
Huh?
on the simple direction to the deputy commissioner to send it to the reference board only. That is my prayer.
Why section 30?
Because it was acquired, my land was acquired under Land Acquisition Act.
That
So I
is-
had filed
that
a
has been-
reference before
that
the
has
deputy.
been, no, that has been repealed. 2013 Act.
That is now repealed. At that time, it was not.
So what is the provision now?
63.
The authority,
Yes,
not the court.
not the court.
Oh.
He has already taken the compensation amount.
Huh?
He has already taken the compensation amount, Your Lordship.
So
No, with regard to ownership only, there's a dispute with regard to.
you have
ownership.
accepted, you have received the compensation?
No, I had not. It was not given to me.
We have annexed the handing and taking over.
No, it was
The
given to
amount
my
of
wife,
an
not to me.
exchange.
Arey yaar, kya baat kar rahe hain?
I'm the owner of the land.
What an excuse.
So
Are
let
you,
it
are
be
you
referred-
separated?
Let this be referred.
Have you
to the- No, I
have you
have not
separated
given
from your wife?
That land belonged to me. Yeah.
Have you, are you?
No.
Huh?
No, not
Then-
separated. Not separate. Not separate. Even I had not authorized my wife to collect the money.
That's why I'm asking. She's your wife.
She is my wife, but they had given it.
Have you
all-
separated from her?
No.
Then
No.
what?
My prayer is only to refer the matters to the reference board only, since I had filed an applications. That's a
You
let
have
the-
accepted the compensation through your wife.
No, I had objected to it. I had, with protest, I had,
It's between you and your wife.
no, with
Fight
protest,
it
I
out
had accepted.
in your bedroom.
With protest, I had accepted yours.
At home, you fight it out at home.
No.
Not before this court. It's strange. Your wife has received the amount, compensation amount. You are saying that I have not authorized.
No, here the thing is that I filed a writ. So it was directed that let the ownership be decided. Without deciding the ownership,
Are you having a dispute with your wife?
no, with the other people, other clan peoples. Not with wife, with other clan peoples. There are another 5 clans who are claiming ownership over the land. So with them, I have a dispute.
So you have no objection so far as the amount of compensation is concerned.
Compensation amount as such is not disputed, but only the ownership over the land percentage, because they had given me 30% of the land, though entire land belonged to me. That is the only disputed part. Because without deciding the ownership, they had made the payment of the compensation.
So you have accepted.
No, I had not accepted.
Who
was
has
given-
accepted it?
It was deposited in my wife without the consent of my wife and me.
Huh?
It was given to my wife without consent of my wife. They just call her and take signatures that they had handed over. So
So-
it was check was in my name only.
So what had happened?
So I had given objections letter instantly,
Huh.
saying that I am not accepting this because ownership need to be decided first.
Then you have you deposited back, refund the amount?
No.
How much? What is the amount?
Amount was something. It's not mentioned here also.
Amount has not been mentioned.
No, amount is not mentioned.
You first deposit, then we'll just hear you.
2 crores, your lordship. It is 2 crores.
My only prayer is to refer the matters whichever is pending.
No, once you have already received the amount and then a strange submission that I have not received, my wife has received.
No, my contention is only with regard to the ownership of the land, not with regard to the compensation, because ownership first need to be decided.
Then why you have accepted it?
No, entire land belonged to me. 30% only with regard to 30% of the property they had given. So that was accepted, but 70% is disputed.
I'll be dismissing your writ petition. Therefore, I'm accepting your prayer. On the prayer of Mr. D.K. the Land Council for the petitioner, list this matter after 3 weeks so as to enable him to file affidavit in reply. That is your prayer. Otherwise, we'll dismiss. Yes. 3 weeks.
Cheers. Obvious.
Your lordship, I beg to mention item number 23 and 24, your lordship. Your lordship, I have checked the noting that the service is still await your. So in the meantime,
Where do you want to go?
your lordship,
Where do you want to go?
your lordship, meantime, like, means, your lordship, I may be allowed to take, the service.
Okay. On the prayer of MS,
Be member for the petitioner.
because your name is not there. 23, 24.
Yes, your lordship.
Your name is not
On
there.
behalf of Mr. Jita.
T. Garam.
T. Garam.
Land records for the petitioner. List this matter. And no, not any prayer. MS so and so land council for land appearing on behalf of Mr. T. Garam, land council for the petitioner. Petitioners is permitted to take precious steps through the mode within 2 days. Within 2 days.
May I please, my lord?
Hmm.
My lord, I beg to mention item number 5.
Hmm.
My lord, allow me to file a rejoinder, my lord.
What reason that?
My lord,
What they are saying? What is the stand?
we will take instruction to
See,
file. the
you have
rejoinder.
donated land.
Yes, my lord.
What do you mean by donation? Once it is donated, how can you claim in lieu of that? What do you mean by donation?
In lieu, some compensation,
Is there any agreement, a valid agreement to that effect?
my lord, I am not aware.
You must be aware. What is your stand?
My lord, my statement is voluntarily donated, and in the entire Arunachal, the entire school, it was donated to the public only. And for against them, but there's no provision.
Is there
for the-
any agreement to
My
that
lord,
effect?
no, yes, no.
No agreement. It's just in verbal and oral
My lord,
those
my lord.
kind of thing. Anyway. On the prayer of Mr. Ensor, Land Council for the petitioner, list this matter after 3 weeks so as to enable him to file affidavit in reply.
Deeply obliged.
This one.
Yes.
Mayor Your Lordship, I'm on behalf of G. Lowland, Council for Respondent number 2 and 3.
Lordship, I'm seeking direction against the NIT to release my 7 and 8 semesters result, Lordship.
Yes.
Yes, Your Lordship, I'm on behalf of G. Lowland for Respondent number 2 and 3. He's out of station for some personal work.
When is coming? After 4 months.
No, no, Your Lordship.
Then Friday, we'll dispose of the matter. Obtain instruction.
Lordship.
All right.
Copy receipt, yes.
He'll be there.
Yes,
Will he be available on Friday?
after vacation or
Sir,
Sorry,
this is seeking release, furnishing of the mark sheet to go for further or higher studies.
Yes, Lordship. Lordship,
Friday
we'll try.
Friday will dispose of the matter.
Yes,
You
yes,
obtain
yes.
the instruction. Tell him to come
Yes, yes, Your
with
Lordship.
the instruction.
All
Right? Heard Mr. is in learned counsel for the petitioner. This is an application praying for a direction to the respondent. NIT AP,
NIT.
NIT AP,
Jote.
NIT AP Jote to declare the 6th, 7th, and 8th semester examination results of the petition and to provide the and also to provide academic transcripts as well as the final mark sheet so as to enable him to and also academic transcripts, provisional degree certificate and the final mark sheet, so as to enable him to
Higher studies.
Apply for so as to enable him to go for higher studies. Mr.
Well, I'm for the respondent number 1.
Is Mr. M. Kato, learned counsel for the learned DSJ, and Mr.
Pita to Your Lordship. Pita to Your Lordship.
To
Respondent number 2 and 3.
counsel for NIT AP, enters appearance and accepts notice on behalf of all the respondent. No formal notice need be served. Where exit copies be furnished to the learned counsel for the respondents. Next paragraph. Considering the grievance raised in this writ petition, the learned counsel to the NIT AP is directed to obtain instruction. List the matter on Friday, 4th or 5th.
Oh, bless you, Lordship.
Don't miss it, Tell him.
Yes, yes, Your Lordship.
Dispose of the matter.
Yes, Lordship.
May I please?
Yes. What happened to other matter? What had happened?
That one?
Other
It was
matter.
pending, my lord, the earlier matter, my lord.
Okay. Did you appear?
Yes, my
No,
lord.
representative,
Yes,
you
yes.
filed the documents.
Yes,
Now
yes.
this is purely on jurisdiction.
Purely on jurisdiction, my lord.
Questioning the jurisdiction.
Jurisdiction, what has happened?
Territorial jurisdiction.
Yes, my lord, territorial jurisdiction. Well, what happened, my lord? In spite of the earlier order, my lord, your lordship order, the lordship was very clear about it, but they don't have the jurisdiction. Lordship, just, I'm again placing that order for my satisfaction, my lord. Once again, my lord, lordship, kindly turn to the page 234, my lord. Order dated 26/2025, my lord.
Yes.
So they have issued, my lordship will remember, they have issued certain notices, my lord, to us for production of the documents for appearance. And their claim is that we have not appeared. And accordingly, on the basis of that non-appearance, they have initiated a proceeding under section 208 of the BNSS, my lord. And the CR case has been accordingly registered, my lord, and the summon and the process has been issued. And that we have challenged. In that challenge, my lord, in the earlier writ petition on, we also challenged that all the notices also. And the lordship can see that the second paragraph of the 235, the considering the petitioner's company, although it's an authorized distributor of the state of Arunachal Pradesh lottery, the selling of the lottery is only in the state of Maharashtra and Punjab with GST registration in the state of Tamil Nadu. And the notices, this is very important, and the notices public summon issued by the GST authority in the state of Arunachal Pradesh and the complaint, comma, being CR case number so-and-so, filed by the GST authority based on which the summon were issued, I am inclined to state the order dated so-and-so, 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 summon dated so-and-so issued against the petitioner by the learned judicial magistrate first class UPI. Accordingly, same has been summoned. However, considering the issue being the pertinent to GST, I am directed that the petitioner shall appear before the GST authority through their authorized representative on 26/6/25, response to the notices by the GST authority. So in response to that, my lord, we have appeared, but the surprisingly, my lord, what happened, my lord? That's a one more cause of action. The representative, in spite of the stay order, he was arrested, my lord. He was arrested. Despite the High Court order, he was arrested by the GST Commissioner and forwarded to the magistrate, my lord. Fortunately, my lord, we have been granted bail because there is a non-following of the 41 notices as per the until judgment, my lord. So now the GST Commissioner again, my lord, in spite of those orders, my lord, he doesn't have the jurisdiction, my lord. Your lordship knows that here, as per the IGST, my lord, the Arunachal is not the consumer. Consumer is somebody else, my lord, either Maharashtra or Sikkim or Punjab. So GST has to be paid either to the Maharashtra, where the Arunachal Pradesh is selling the tickets. Here, the Arunachal Pradesh is an organizing state, no doubt about it. But organizing state does not mean that they are selling. Arunachal Pradesh, the lottery is absolutely banned, my lord. There's no lottery at all. But they are selling the tickets through us. We are the authorized representative to dealership, my lord. So we are selling not in Arunachal Pradesh because it's a ban. So we are selling it either in the Maharashtra or in Punjab. And accordingly, we are paying the GST on behalf of the Arunachal to the respective states. That's clear from the annexure also. So now the GST Commissioner, he has a different kind of a notion and he is issuing notices after notices. Then we are defaulting the GST here. And accordingly, he is trying to sometimes the criminal case, sometimes the notices, that's just going on. So that's the recent position is that in spite of the High Court order, the one person, our accountant, he was being arrested who was representing the company. That's the lordship. We have the certified copy of the arrest memo because the last day it was the holidays. These are the only copy given to us. The certified copy, that is the arrest memo which has been provided to me. And the bail order and the certified copy also here. Yes. So, my lord, humble prayer at this stage, my lord, said no coercive step must be taken against the petitioner, my lord, in respect of this particular dispute, my lord, or to his representative, my lord, whatever, my lord. That is at this stage, that is the prayer, no coercive state, because they are having, my lord, the issues and notice. Lord, you kindly see that the page 120, 225, 146, which we have challenging, they are still calling up some of the documents from us. Even today, they have issued summon to us. That's a different issue, my lord. But they are issuing notices. So without having the jurisdiction, my lord, which is the apparent, no cause of action, my lord. for them to adjudicate, my lord. Adjudication has to be, so my lord, at this stage, my lord, that to file my prayer, that has to be called for from where it is originating. File may be called for, and till then, my lord, no coercive against the petitioners, my lord, in respect of the GST matters, my lord. That's all, my lord.
Lordship,
When the notices are stayed, suspended, why have to arrest them?
Lordship, as per the GST, this, if you see this rule
Right.
16, where means actually after inquiry.
It's okay.
Yes,
We'll decide
yes,
that.
Yes, that's a suo moto one.
First question, why you have arrested them?
Okay, now that the order dated that means regarding criminal complaint before the JMFC, that's a different case. That's a non-compliance.
That notices have been stayed.
Yes.
Yes.
In a criminal case.
That summon has been issued by the Honorable Judicial Magistrate. Now here this case is about the tax evasion. That's a different case. Both are different. And for Judicial Magistrate, that's punishable only for 1 month. That's under Section 208 of BNS.
That's what I'm saying.
Yes.
Wrongly or rightly, whatever. This court had stayed the notices.
Yes.
Lordship, here in this, that's both are different proceeding. So after
That is-
recording statement of that authorized representative, so all the statement, after subscription of all the statement, then there is a law here as per the CGST, they invoke 132, section 132, where means those offense are defined. And subsequently, commissioner has authority to, if there is a prima facie case, reasonable ground is there, then commissioner can invoke section 69 of
This summons is not which has been stayed by this court. Is
And
not
the notices.
in the CR 45.
Yes, that is my
They
lord.
have been arrested. He has been arrested under in the case of CR 45.
No,
No, no.
they are not arrested in CR 45.
No, no, my lord.
They are not
have
arrested.
Again,
Lordship.
they have registered a new case, my lord.
New case.
This time, the representative who has gone to attend on behalf of us, my lord, there's a new case has been registered, my lord. So, my lord.
This file number 4. File
Yes.
number 4.
Yes.
Yes.
In this only he has been
Yes,
Yes.
everything is. So
Yes.
that's my humble consider that
Okay.
that should be called for, and the anything in pursuant to the file number 4 may be stayed, my lord.
Lordship, here on record, as per the
That is
statement
because
subscribed.
he doesn't have the jurisdiction.
No,
That is the order.
now I will establish that jurisdiction as per the rule 16 of CGST 2017, where here in this case, Lordship, this court need to understand difference in RCM and forward charge. Here, state government issue law 3, and on behalf of state government, this person, this future gaming is bound to pay the reverse charge. But they are saying that they are not bound to pay over here, and they are saying that they are not bound to register over here. Since RCM is to pay on behalf of state government to the state of Arunachal Pradesh, not to the other state. Now, here
Let us
they are
see-
evading.
Let us see the provision.
Yes.
My lord, regarding the RCM what talking about, that is the one-time payment, that is the beforehand. Before the issuance of my lord, we have to pay on the basis of the tickets. On the basis of the tickets, we have to pay. And that too in advance, my lord. And like that says one component is a guaranteed component, my lord. We are paying that part. We are not only reverse mathematics, my lord. Their claim is that we have to register it. Lordship kindly see. Their one claim is that we have to register it here, where there is no cause of action, my lord. And thereafter, we are evading the taxes, the GST.
Where it is?
That is their case, my lord, in the
Lordship,
original
section
complaint itself.
24.
In the original complaint, that's the 49,
49.
page 49, the paragraph 2. So we are here admittedly only the distributor, my lord. On the basis of an agreement. So based on a specific intelligence investigation and initiated shown Future Gaming and the hotel services, who is engaged in distribution of lottery tickets on behalf of the government. So it is on behalf of the government, we are selling it to either to the Punjab or to the different states, my lord. So so basically what is the GST, my lord? The consumer belongs to those person who in that particular state, my lord. Here, notice the consumer not in the Arunachal, consumer either in the Maharashtra or in the Punjab. They are paying the GST and we are collected and we are depositing on behalf of the state of Arunachal, my lord. So that's the, so we are here neither to, we don't have the, they don't have the jurisdiction at all. And without having the jurisdiction, he has issued the notices and the notices, which has been earlier stated, my lord. Even here, even the printing of the tickets are not in Arunachal or supply of the anything, not even in nothing. Only they have issued the authority letter. The NIT has been issued. We have participated. So here is the allegation of the evading of the GST during the period 2018 to 25, my lord. So we are going to the basic root of the, and lordship is prima facie satisfied in the earlier litigation that there is no jurisdiction at all. That's why lordship has granted stay of the all the notices and the summons. And they directed the representative to appear, my lord. And we have appeared in Agwin, we have been arrested. By this time, a fresh case has been issued.
Lordship may read section 24 of Central Goods and Service Tax Act 2017.
Yes.
Compulsory registration. In certain cases, notwithstanding anything contained in subsection 1 of section 22. Section 22 is about the process of registration. The following categories of persons shall be required to be registered under this act. Here means person making any we are not into Roman 1 and 2, it's Roman 3. Persons who are required to pay tax under reverse charge. And Roman 4 is person who are required to pay tax under subsection 5 of section 9. And section 9, lordship may turn section 9 clause 5. The government may, on the recommendation of the council, that's a GST council, by notification specify categories of service, the tax on intra-state supplies of which shall be paid by the electronic commerce operator if such services are supplied through it, and all the provision of this act shall apply to such electronic commerce operator as if he is the supplier liable for paying the tax in relation to the supply of such services. So they, and subsequently lordship may read section 2 definition part. What is supply? That's section 2 subclause 105. Supplier.
Supplier.
In relation to any goods or services or both shall mean the person supplying the said goods or services or both, and shall include an agent acting as such on behalf of such supplier in relation to the goods or services or both supplied. So after reading this, lordship may go go through this CGST rule 2017 rule 16. How this they are paying for forward charge only from here to state of Maharashtra and state of Punjab only. We are into that you are supposed to pay in between state of government and you, which state of government bound to pay, but we cannot collect from them, that they are not registered person. And as per section 24, they are supposed to register here, but they intentionally evaded. That's from 2018, and for 1 year only they evaded 98 crore. That's on record. That's in digital record. And subsequently here rule 16. Rule 16, it's about the suo motu registration by the inquiry authorized officer. Lordship rule 16 of CGST rule 16. Suo motu registration, where pursuant to any survey inquiry, inspection, search, or any other proceedings under the Act, proper officer finds that a person liable to registration under the Act has failed to apply for such registration, such officer may register the said person on a temporary basis and issue an order in Form GST-R registration 12. So based on this officer, the person who is inquiring this case, they have to do the suo motu registration because they are intentionally evading the tax of this state government. That's on record 2018-19, that's 98 CR. Now remaining, they are not just disclosing those record, the lottery record, whichever they are selling out of the state. So by making excuses that we are not bound to register over here. Now here, they have been registered now, your lordship.
So you file your reply.
Yes.
The affidavit will.
Yes.
Will provide that you don't take coercive action.
My lord,
Lordship,
Or else will
Now-
stay the proceedings.
my lord.
okay, no coercive action that will do. But lordship, here,
The reverse,
here
the
actually
reverse
it's a
mechanism-
time-bound recovery, lordship, and today is the last date.
No, no.
And
no.
today is the last date to that.
No, no, there's another 5 years.
Will provide that no.
That's not,
Coercive action. I think it needs to be.
when matter is
Let- let
subsidized, my lord,
deliberate.
there have,
Yes.
there's opportunity.
Because
and
they are
have-
misleading this honorable court. That
No, no.
criminal complaint, magistrate court is something different, and
No,
this is something. Both are different
Let
cases.
me-
No, that I have understood.
Yes.
Now they have been.
No, no, the
arrested. Why not
criminal
contact-
complaint has been originated from the notices.
Yes.
When the notices itself is the bad,
Hmm.
then where is the question of the criminal case? We have challenged the jurisdiction of the issuance of the notices. When the notices itself, the prima facie is bad, there's no question of another criminal case. So that is why, and regarding the reverse case, my lord, reverse charge, what they are saying, my lord, lordship, there's a new notification. Probably he's not aware of this notification, my lord. This is reverse charges. This is now only related to the promoters. This is the new notification, my lord. It's come up on as amended. Lordship, can you see the reversers and the recipients of the goods are the promoters. So that formula is not applicable. So this is only applicable for the suppose there's a Amazon, Flipkart, etc. This
Lordship,
online trader 9.5. So this is not the case, my lord. This is 9.4. So what he is saying that the reversal that is not applicable here, my lord. So apparently, my lord, prima facie we have a case, my lord. So lordship kindly stay the proceeding, my lord. In the meantime, let them file and let them place the records, my lord, that we are evading the taxes.
Yes, we'll see. Let them file the response. Will not stay the proceedings. We'll say we'll provide.
No coercive
No
action, my lord.
coercive action.
No coercive action in respect of the petitioner, my lord.
All right. It needs to be deliberated upwards. Third Mr. Ankshum A. Bora, Learned Senior Counsel, assisted by Mr. Learned Counsel for the petitioners. While the challenge in this petition is to the inquiry initiated being file number for Roman Pora, within bracket 06, bracket close 01, oblique miscellaneous oblique AE oblique HQRS oblique ETA oblique 2024-2025 by the GST authority.
yes, here they made party to this respondent number one.
Who has initiated?
This
Commissioner.
someone is being initiated by the SP superintendent.
We'll
So-
say GST authority.
Yes,
Madam.
yes.
GST.
Lordship, it may write as yes, CGST Itanagar Commissioner. And respondent number one and two are same. Lordship.
Commissionerate. Against the
Respondent number one and two
petition-
are same person.
On the ground,
Second is by name, my lord.
the authorities is not a proper officer, right?
My lord.
In terms of the Section 70, 73 and 74
Yes.
GST Act. Next paragraph. Mr. Abraham, Senior Counsel, submits that as per the provision of CGST Act, the Commissioner GST and CX Commissioner Eternal has no jurisdiction to initiate any inquiry against the petitioner. As the petitioner is not selling any lottery in the state of Arunachal Pradesh, though they are authorized state lottery distributor. And the
In
selling
terms of
lottery,
agreement, my lord.
in terms of the agreement
Between the government of Arunachal Pradesh.
and the lotteries are being sold in the state of Maharashtra and Punjab.
Maharashtra and Punjab, my lord.
Even in
Maharashtra
Sikkim
and-
also, yes.
And the Sikkim also.
3 states.
3 states we
Maharashtra,
are selling, my lord.
Punjab and Sikkim,
Sikkim.
where the GST registration, with the petitioner has registered the GST and paying the required taxes to those states. He submits that the since the petitioners are not selling the lotteries in the state of Arunachal Pradesh, they are not required to
Sikkim
register
have
themselves
incorporated already.
under
Sikkim is there. Manjivan and.
CGST Act. Under CGST, registers
You
CGST.
have incorporated it in petition.
Therefore, the initiation of the proceedings, inquiry proceedings is without jurisdiction. Issue notice returnable by 4 weeks.
4 weeks, my lord. Let it be, my lord. Come along with the WPC, my lord. 281.
Just wait. As Mr. T.T. Kipa,
Yes, Lordship.
learned counsel, enters. You are for respondent number 4.
Yes,
And Mr. Learned Counsel and Mr. Arichanabam, Learned Additional Advocate General, enters appearance and accepts notice on behalf of respondent number 1 and 4.
Lordship,
These 2 and 3 are by name.
one
You'll have
and 2 and 3 are not required actually. If that officer.
Anyway, since they have to take steps.
We'll take steps if
One-
necessary.
1 and 2 are the same person, same authority.
By name, they are by name.
By name we have incorporated
But
because
cannot-
we have alleging malafide also.
Yes, they are alleging malafide.
That's why, my.
2 and 1 and 4, no formal notice need be served. However, extra copies be furnished to the so-and-so. Petitioners to take steps for service of notice upon the respondent number 2 and 3 within 2 days by register so-and-so, so-and-so. Next paragraph. Considering that the petitioners, though a distributor of state lotteries of Arunachal Pradesh, they are selling the state lotteries in the other states and paying the required taxes
On behalf of the Arunachal.
after registration under the GST. And the authority appears to be prima facie. And what you are paying here in the state?
My lord.
You said one time you have made a payment. What tax you have paid?
Oh, tax, my lord, initially we have to pay that's the agreement. No?
What tax? What is called?
That's why reverse charge.
That
Actually,
is,
lordship.
that's not the reverse charge, my lord. Payment.
That's
MGR. That's a minimum guarantee, my lord, on the basis of the tickets, my lord. Because that's a basically we have to, lordship kindly see that
Anyway,
is-
since you are not staying the proceedings, only no coercive action is
Yes.
provided. We'll say, and paying the, what is called?
MGR, my lord.
What is
Minimum guaranteed
Huh?
revenue, minimum guaranteed revenue, my lord.
Minimum guaranteed revenue to the state of Arunachal Pradesh. And prima facie appears to be a not proper officer, comma. It is provided that no coercive action shall be taken against the petitioners. You proceed whatever, but
yes.
that's a no coercive action.
My lord.
Minimum required guarantee.
Minimum requirement. In terms of the
It's not a part of the GST.
minimum guaranteed MGR.
Ah,
That is revenue, my lord.
revenue only.
Revenue.
It's not on it doesn't fall under the CGST.
No, it doesn't fall under.
This is
it.
different.
That is,
Lordship,
that's
that's
for
a
the
private
agreement, my
MOU.
lord, because that is comes within the Lotteries Act, my lord.
That's lordship. If suppose someone get L1, then there's a MOU in between them.
Yes.
And we are not into that MOU. We are into the tax only.
Yes, yes. So we find that
Yes.
if they are
that agreement-
if they are selling the lotteries,
Yes.
I mean subject to that's why I said prima facie.
So
When
yes.
you're saying that,
Yes,
Yes,
and my lord, this is, we are selling it on the basis of the Lotteries Act, my lord.
yes,
So that agreement in pursuant to the Lotteries Act and the rules governed by, my lord.
we'll consider. I mean, this is
So
something.
no coercive action in respect of the petitioners, my lord,
Yes, yes.
in regard to the, my lord, GST. my lord.
Yes.
Or the
Yes,
representative,
GST pursuant to the proceedings or
Well,
inquiry.
my lord,
That
pursuant to the proceeding.
inquiry number so and so, so and so. These proceedings only.
My lord.
Yes.
List the matter along with WPC.
My lord, this, along with him, my lord, WPC 281,
Hmm.
2025.
Ah.
Petitioner and the authorized representative. Obliged, my lord.
Highly obliged.
May I please, my lord?
Can I take up this matter?
To my mind, my lord can, my lord, because my lord,
Because
I am relying on the, my lord, second part of the judgment of my lord, my lord. My lord,
basically where ultimately your relief would be if you are provided.
Yeah.
I mean, grant the relief of retrospective promotion, then only you will be above them.
yes, my lord.
All right.
My lord, problem is that, my lord has, my lord, in the judgment, my lord has said that, my lord, from 2008 to 2011, they admitted that there is no vacancy, my lord. Clear vacancy for which we can be considered, my lord. I can be considered. For which, my lord, we have filed a writ appeal before this division bench, my lord. And second part of the judgment says, my lord, to work out, my lord, the vacancies, my lord. As government has admitted that, my lord, they are trying to work out the vacancies from a date-related back, my lord. So, my lord, the process was there, my lord. Suddenly, my lord, it was stopped, my lord. And even assuming that, my lord, from 2009 for a limited period, my lord, 2008 to 11, there is no vacancy, my lord. But, my lord, there is, my lord, vacancies from 2013 to, my lord, 2017, my lord. From last DPC was held in the year 2012, my lord. That is for regularization of the certain persons, my lord, who were given officiating promotion, the degree holders, of the vacancies of 2008, my lord. Now, my lord, thereafter, my lord, 2012 onwards, my lord, no DPC has been convened, my lord. Since, my lord, up to, my lord, 2022, my lord. So we filed the writ petition, my lord, saying that we have to be given a retrospective promotion from the date of officiating promotion, my lord. But that was, my lord, denied by lordship, my lord. However, my lord has directed to take an exercise, my lord. Now, my lord, The person, I was never reverted back from the officiating promotion, my lord. My lord, the persons who were holding the officiating promotion as a AE against the direct recruitees, my lord, in order to, my lord, fill up those selected direct recruitees, my lord, those 20 persons were reverted back, my lord, in order to, my lord, fill the direct recruitees, my lord, in the 2012, my lord. Then, my lord, on the same date, my lord, those 20 persons were again reappointed on officiating basis, my lord.
Let us take his view. Can I take up this matter?
I'm not sure, my lord.
No, you say, you give your opinion, your view. Because this court has dismissed the writ petition.
Yes, ma'am.
Where the petitioner has claimed for retrospective promotion, right? Promotion with retrospective
Yes, ma'am.
effect. Now that is pending before the division bench, right?
Right.
Now, while dismissing the writ petition is provided to look into the thing in view of the facts situation. Now they have started the proceedings, and then in between they have stopped it, and they have issued a provisional certificate. I mean the seniority. Whatever the provision, it's provisional only.
Provisional, my lord. But, my lord, I have made a specific statement that, my lord, on the basis of that provisional seniority list, my lord, they are going to fill up the promotional post of executive engineer very shortly, my lord. That is the, my lord, main problem, my lord.
They will say outcome.
My lord, that will be very difficult
They
in
will
our.
say one post may be kept vacant.
My lord,
Because
that-
it will be difficult to stop the DPC.
My lord.
I mean, as a whole.
Because, my lord, in fact, we will be the, my lord, in a receiving end, my lord, because all the direct recruitees, my lord, who were appointed, my lord, in the year 2013 and 17 were placed above me, my lord. Admittedly, we have been in the cadre of assistant engineer from 2009 onwards, my lord.
Have you filed a provision in the sense you have been allowed to file a representation claim?
And we have filed the representation, my
You
lord.
have filed?
Yes, my lord.
It has not been considered?
Not considered, my yet, my lord. Or, my lord, may.
Then in that case, if you have no objection, we'll see.
Yes, my lord.
Heard Mr. R.C. learn consent for the petitioner. Next paragraph. Challenge made in this petition is to the provisional inter-C seniority list of assistant engineer within bracket E bracket close, published by the respondent authorities by memorandum dated 25/01/2025 in the Department of Power, on the ground that same has been published without reviewing the DPC, which is under process. Without the review, without considering the claims and objection of the representation filed by the petitioner, by which where is that provisions in the list?
My lord will find at page 114, my lord, 174, my lord. And my name appears at, my lord, 176, my lord, page.
You are
Yes.
claiming against whom?
My lord.
Against whom? Is there any private respondent?
Yes, yes, my lord. I have, my lord, up to, my lord, serial number 28, my lord. Who were, my lord? Up to 27, my lord.
The name of the petitioner, the petitioner is positioned at
serial number 29, my lord.
paragraph 29. No, page
Page 176, my lord.
76.
Marto Kamgo, my lord. Serial number 29, my lord.
Position at serial number 29.
29, my lord.
Position ED, huh? 29. Below the
Direct recruitees of 2013 and 2017, my lord.
below the direct recruitee of 2000
13 and 2017, my lord.
2013 and 2017. Within bracket, the private respondents.
Private
They are
respondent.
private respondents.
Yes, madam.
Private respondents hearing. Issue notice returnable by 4 weeks. As Mr. L. Perme. For all the respondents, no, all the state, the official respondents.
Two, my lord.
Two, my
It should be two, my lord, but it indicated three here. Two, my lord. And for two, Commissioner Power Department.
You are also appearing. Mr. MS K. Wang, London District Council, and Mr. L. Perme, London Council, Standing Council for Power Department. Interest appearance on behalf of respondent number 1 and 2.
One, it should be two, my lord.
It should be two, my lord.
But it reflect as three, my lord.
1 and 2. You correct it.
My lord, I will correct it, my lord. I'm sorry, my lord. And I will take notice upon
One
the
and
private
two,
respondent, madam.
No formal notice need be served. However, executive will be so and so and so. The petitioners to take steps for service of notice upon respondent number 4-2. 4-2.
And after correction, it should be, my lord, 3-2, my lord.
3-2.
3-2, 28, 29, my lord.
3-2. 29. Yes. By registered person and so and so within 2 days from today. Within 2 days, just like that. Having considered considering the submission of learned counsel to the petitioner that the responding authorities are contemplating to conduct DPC for
Yes.
promotion to the post of
Executive
executive
engineer.
engineer on the basis of the impugned provincial seniority list. It is provided that one post of executive engineer. No, Mr.
Or my lord,
It is
I'm
provided,
sorry, my lord.
in the
Or my
event
lord,
of
my lord may provide that, my lord. Till my lord, finalization of the seniority list, my lord, no promotion may be made, my lord.
that will be too harsh.
Because my lord,
We'll just say keep one post because we don't know whether the permission they will have the DPC or not. We'll just say one post.
My lord will kindly take note that the other candidate, my lord, also will be there similar to the petitioner, my lord, in this case.
That's why we're not stopping. In the event the DPC is conducted, one post of executive engineer.
my respectful
Kept
submission, my
vacant.
lord, for DPC, my lord, there has to be a final seniority list, my lord. But
In the absence of the can, what's there if there's urgency?
my lord,
And we'll then and considering that before that, and considering that the final seniority list, no, the final seniority list has not been finalized
my lord.
as of that, comma, it is provided that one post of in the event the DPC is conducted for promotion to the post of executive engineer, within bracket E, bracket close, one post of executive engineer so and so may be kept vacant. Will not disturb it. List after 4 weeks.
Okay.
Obviously.
Yes.
I'm from the petitioner's side, behalf of K30. Private respondent 4 and 5 are yet to be filed affidavit.
Who is private respondent number 4 and 5?
Your Lordship, I'm appearing on behalf of Mr. M. Karpa for respondent number 4.
Ha. So
Your Lordship, time I'm granted to file an affidavit in opposition.
you have been granted long time back. Yes, what is the matter? Yes, what is the matter?
Lordship, I'm not aware of the fact that my senior told me to that.
You have the brief. Do you have the file of this matter?
Yes, but I'm not aware of that fact.
Why you are not aware of the fact?
My senior has told that he's have personal.
Can you not go through the petition?
No. No.
Huh?
No.
Who is preventing you?
K30.
Who is restraining you?
K30.
K30 has restrained you
No.
from
Not
going
restrained.
through the brief.
No. Actually, I'm not prepared this.
Why you are not prepared? Yes, what is your stand?
My lord, my stand is, my lord, there's the case, my lord, the person who is junior to the petitioner, my lord, they were considered on the ground, my lord, because when DPC was held, my lord, an advance notice was given to the petitioner, all person, my lord. His required document, as here, the other document, relevant document, including B.Ed certificate, that was not submitted, was not placed before, my lord. So accordingly, the DPC authority, my lord, the Department of Proceeding, they have examined because he was not eligible at that point of time, my lord. So accordingly, the person who were John of considered were eligible, they have been recommended. And
Why was not eligible?
My lord,
Because of the lack of documents.
Yes, my lord. He had not submitted B.Ed because for the further promotion, my lord, B.Ed degree is required, my lord. But B.Ed degree or required document was not submitted to the authority. And authority, when it's not available, the DPC has to go on as per record only. And he was not eligible at that point of time.
No, eligible in what sense?
Eligible,
Under
my
the
lord,
rule, he was not eligible.
my lord, B.Ed degree, my lord. This all that has to be submitted, that was
For
not
promotion,
there.
promotion.
Yes, promotion. But now later on he has been promoted, man.
He's asking for retrospective because his juniors has been promoted. Juniors
My
have
lord.
been promoted.
So that's why, my lord, let the petitioner, private respondent also, my lord, come in, my lord. And
No,
they are-
will not interfere their appointment promotion. We'll say provide him from the day when the juniors were promoted. The requirement is B.Ed.
My lord, B.Ed.
As a TGT, what is the requirement?
As a TGT, my lord, as per RR, my lord,
So for PGT, the B.Ed is required.
my lord,
And when the materials, when the DPG was conducted,
my lord,
he was not having that.
that
B.Ed
required
degree.
document, my lord, that was not before
Yes.
the authority.
Lordship, kindly this matter after petition. So we need the time.
We want to allow the writ petition. When the DPC was conducted for promotion, when these juniors were promoted, 2011 and 14. You have annexed the minutes? of the DPC?
My lord, minutes, my lord, earlier DPC minute, my lord, it's not there, but
Then how do you know that he was not eligible? Considered and found to be eligible. Admittedly, he was senior. Which is a private respondents. Where is the seniority list? Page 38. What is the name of the petitioner?
Passing Singh.
What is your name? This is PGT. What's your name? Yeah.
My lord, it's record is his name is not. We'll have to verify the my lord. Last night, actually, petitioners said they call and they will take time. That's why my lord, this part.
See,
This,
both of these, they were appointed on the same day, 22nd June 2009. Where is the seniority list of PGT? This is PGT.
PGT, this is not.
Sir, where is the seniority list?
Lordship, I'm not,
My lord, it appears the seniority list is not there, my lord.
Sir, on what basis he's claiming? He's saying that I is senior to the respondent number 4 and 5.
Exactly.
And the appointment as a officiating, teacher to officiate as TGT, they were appointed on the same day, 22nd June 2009.
Exactly, my lord.
Page 21, 19, 20, 21. And I don't find any
Appointment is same, man.
I don't know
My
why
lord,
he
it's
has
not-
annexed this Annexure C.
Appointment, as per appointment, they are appointed on same day on. But when they were considered this private respondent, although they were together, they were considered, but when it was taken up before the DPC, that required document that required to be submitted by the petition that had not been available, was not available.
Next time, if you are appearing in a matter, don't just come like that. You are a lawyer. Come prepared, huh? Heard Mr. So-and-so, learned counsel for the petition, and Mr. Teacher learned counsel for the education department, standing counsel for the education department. Mr. On the prayer of Mr. So-and-so, learned counsel for the respondent number 4 and 5. 4. Who is for 5?
4 and 5 is also.
Respondent number 4. For that 3 weeks time is granted to file affidavit in office. Declare. No affidavit, what is the matter?
We have filed our affidavit.
You have filed?
Yes. It was
Okay.
filed on 29 April. Also.
Okay, huh? Yes. Direction for register the FIR.
Right.
So-
Here was if approval has not been given. Page 62. Also.
62.
Yes. Because under section 17A, the approval of the competent authority is required. Is under the case is under the PC Act also.
Who is appearing?
Seems petitioner counsel is. Posik was.
So vigilance has rejected
Close.
disposal of the complaint.
Oh, yes.
You have asked for an. Did you ask for the approval?
Yes, the SIC has asked for the approval and we have rejected.
Rejected.
Yes. The page 62 is
So they are challenging it.
no, they can challenge this process.
They are only asking for the same.
Yes. This writ petition has been filed prior to passing of this order.
Well, dispose of the matter, will give them a liberty.
Yes, they can file
Yeah.
challenge this the order. Rightly or wrongly, we have decided not to grant approval.
Law appears for the petitioner on call. But will it be proper without hearing them? What to do?
Otherwise, lawsuit can give one chance.
Next year. Outstation. Law appears for the petitioner on call. Mr. Estapin, then the senior government advocate, and Mr. Opada, then standing counsel, SIC. Huh? ACB. Okay. Anti-Corruption Bureau, ACB. Correspondents are present. As a last opportunity. Considering the nature of the prayer and the extent of the respondents. And the response by the respondent. Come on. although it appears, the petition may not be survived now for any adjudication, as a last opportunity. The matter is adjourned for 3 weeks. Yes, affidavit. Who is to file affidavit?
Lordship, this is the case arising out of the rejection list prepared by the Deputy Commissioner. Lordship, in this case, in this matter, the rejection list has already been challenged in two sets of litigation, Lordship. One is 03 of 2023 and two is 393 of 2024, Lordship. Lordship has already disposed of the 393 of 24 as covered case, Lordship.
Who are the respondents?
Lordship, I'm for respondent number 5 and 6 on behalf of DSTI M. Kato.
5 and 6.
Yes, Lordship.
So what is your prayer?
Lordship, we may be given some more time to take instruction from the competent authorities.
Yes, madam. 124. Where is that order? Have you annexed that?
Yes, Lordship. Page number 193, Lordship.
193.
Yes, Lordship. Yes, Lordship. Judgment. In this matter, Lordship, the issue has already been determined, Lordship. Issue has already been determined, Lordship, in favor of the petitioners, Lordship. Now, Lordship, here the challenge is of the rejection list prepared by the two sets of rejection list prepared by the Deputy Commissioner, Lordship. In this 3 of 23 also, they have challenged the same impugn order, impugn rejection order, Lordship. And page number 200. Which Lordship has disposed the metro as a covered case, Lordship.
Which
and
one?
the issue is arising out of
Page?
same page number 200, Lordship.
The same, that the public notice of issue so and so is not according to any violation.
Page number 203, last para, Lordship, para 7. Para 6 and 7 is.
Yes, separate impugn orders are there.
No, Lordship, same impugn order. In same list, my name, the name.
You are not the petitioner in the earlier proceeding.
No, Lordship.
That's the only difference.
Yes, Lordship. That's
Otherwise, you
yes.
have been excluded by same
Same rejection
order.
list.
Same order.
Yes, Lordship. Same rejection list.
What is there? Same order.
Lordship, actually, for the Deputy Commissioner, respondent number 4, someone has filed wakalat nama, some other
council has. So, Lordship. I
Who
cannot
is
answer
filed
here.
that?
Advocate.
But you are for the state,
Takam Sunil.
huh?
Specifically, he has come for this deputy commissioner. So, Lordship.
But then you are for the state only.
Lordship, this.
What do you say? Whether this covers or not? If he or she is not appearing, we cannot wait for them.
Lordship, I didn't follow. There was in the same matter, there was a review.
Lordship, find the rejection list.
Huh? You
In the-
just go through it. We'll dispose of the matter.
Lordship.
Just go through it, whether this matter is covered or not. Subsequently, this court has held that earlier it covers. What he's saying that only they were left out from this petitions.
Lordship.
And otherwise, it's the same order.
Lordship.
So simply provide it's a covered case. Huh?
All right, Lordship.
That's right. Heard, Mister. If you have any doubt, you may. I will provide you some time to go through. Same order. Page 200.
Yes, page number 200.
200.
And one is page number 193.
No, we'll not go into that.
Yes, not sure.
I think this 200 will do.
Yes, not sure.
Hmm? Heard, Mr. Aringo. Want to confirm it? I want to make yourself sure.
Lordship.
You want some time to go through? Time being, or do you agree?
Lordship, Lordship can pass the order.
Yes. Aringo, learn counsel for the petitioners. And also heard Mr. MSG at learned addition. Additional senior government advocate for respond number 1, 2.
1, 2, Lordship. 1, 2, 3.
1, 2, and 3.
Yes, Lordship.
Non appears for the respond number 4, despite filing of power. Despite even after filing of the power. And Miss, no, before that, huh? And Miss MS so and so, done with counsel, appearing on behalf of Mr. M. Kato. Then the DSGI for respond number 5 and 6.
Yes.
Then you write, huh? The non-appears for respond number 4. Non-appears for deputy commissioner, respond number 4. Even after filing of Wakal Lama. Then you same order.
Yes, not the same order.
Victor, page 200. Only you just said by filing this petition. How many petitioners?
61 petitioners.
Then by para 3, you just say petitioner. The petitioner, 16 numbers, huh?
61 percent.
61 in numbers, huh? Claim took the honors and others. Pene village.
Yes, Pene
Pene village
Tato.
to-
Yes, it's the same stretch of
From
road.
Pene village to Tato. Disclosure. Huh? Much appreciated.
Okay, Lordship.
Yes. 13.
Yes, Lordship.
What is this?
Lordship, in 13, the registered respondent, they have filed their affidavit,
Hmm.
opposition. So I need to file a rejoinder. In their affidavit, they have annexed one map page number 67 and shown to have cancelled. However, this is not the map that I have processed now.
The prayer, Mr. Learned counsel for the petitioner. List this matter after 4 weeks so as to enable him to file affidavit in reply to the affidavit in the position filed by the respondents. Have you filed the affidavit?
No, Lordship, we are yet to receive instruction from the competent authorities.
SIB is
Main part.
central government.
Yes, Lordship.
To the state affidavit is filed by the state respondent.
Otherwise, Lordship, I am not
Further-
disputing the fact that
further-
they have possessed the land.
Further,
Never
Mr. Ms. So-and-so, appearing on behalf of so-and-so, is also granted 3 weeks time to file affidavit.
Obliged, Lordship.
No affidavit. 126. Which 126?
The 14.
Which 126?
No, because this government, they have decided to
Not to
rely
file.
on the records only.
Why? Yes. Ready? Is there interim order?
Yes,
Huh?
yes,
In your favor?
yes.
Who is carrying out, who is working, who is carrying out the work?
After that LOI, we have carried out for 2 months.
Ah.
And then because of this stay order, we have been.
Government,
Continue.
government is running
For
the,
2 months, we were carrying out the.
Hard Mr. Empathy, London Senior Counsel, assisted by Mr. K. the London Counsel for the petitioner. And Mr. Aditz Nabam, London Additional Advocate General, as well as Mr.
Seven.
T. Tara, for respondent number, for respondent number
7.
7.
6 and 6 in 95 and 7.
Writ petitions are admitted this for hearing after 2 weeks.
Well, that
3 weeks.
interim order is there because that, my can take up for this.
We'll say-
interim may be continue.
And endeavor
That is
shall,
difficulty,
and endeavor shall be made to dispose of the, no. You fix that, we'll give the fix that.
Fix.
Just after reopening.
No, madam,
I hope I have been admitted.
Can you take up? today?
He is also not taking up the, he is not working on it.
No, madam, there is a.
You are also not carrying out the
No,
work.
for 2 months I was working.
Anyway, we'll this,
Madam, the issue is very simple. Madam, kindly take a call this way. or-
sir, we'll decide it. We're admitting it, fix it for next date.
Admission
You choose the date.
It's the admission.
Come back with fresh mind.
Well, 1 week.
No,
After
madam,
1
the
week.
simple
Huh?
issue,
After break or after 1 week?
madam, the
Okay.
simple issue in this case, only on one court. The first writ petition 95 was filed, there was no interim order. The second writ petition, that is 1111, was filed by suppressing a material fact. because he has withdrawn the EMD and thereafter he has filed. In paragraph 27 of the read petition, he has only mentioned that we have filed the read petition number so and so, but he has not disclosed this. And therefore, a person who has withdrawn the read petition, EMD, and filed the read petition, how it is maintainable, my lord? That is the only question to be decided today. On the facts also, my lord, they don't have any.
Him was hurt to both parties. He was
Okay,
impeding.
you delete it. We'll take it up at 2 o'clock.
Correct.
Yes.
We're entering into the merit. If
Correct,
we-
my lord,
if we-
my lord.
if we take it up for
5
overstay.
minutes, my lord. Max. I'll take 5 minutes, my lord.
Yes. 2 o'clock we'll hear the merit. Yes.
Matter relates to cancellation of GST registration, my lord. Matter relates to cancellation of GST registration, my lord. Petitioner GST registration was cancelled, my lord, without assigning any reason, my lord. Lord, so you'll find it the order.
I think we have disposed of similar matters where it is.
One of the order I have annexed, my lord, and the lordship has also passed similar orders. I have just made a compilation. The lordship order is at page 44 in my compilation. I've given a compilation, lordship. In the compilation, lordship order is at page 44. Start from page 45, my lord. Page 45 is the lordship order. Page 44, 45, my lord. Forty-five is.
Yes, which for the respondent? Which there's central.
State GST is the party here, my lord. Here, state GST is the party.
Okay, not the central.
Not central, my lord.
Yes, it's also covered. Same.
Covered in the sense, lots of facts are different. Here, we have given them notice and then they haven't replied the notice, so-called notice also.
Have you filed a reply?
No, my lord.
They haven't filed reply, and from the inception, they haven't filed return also.
We'll tell them to file.
Subsequently, we have filed till the date of cancellation. We have filed our returns.
After the cancellation, but then
Till the date of cancellation, sorry, my lord. Till the date of cancellation, we have filed our return. Subsequently, my lord.
Till the date.
Date of cancellation, after portal is not allowing. Once they revoke, then we can file our subsequent returns.
We'll provide that, which we have provided here. You check this.
Yes, I provided.
Yes, lordship.
The same thing. He has filed till the
date of cancellation. I have filed
till the date of cancellation. You have already filed. Thereafter, he could not because until this is revoked. We'll provide them to deposit, and on his deposit required taxes.
Up to 4 crore his balance is there from the beginning. 5 crore. From 5 crore he have given. He have recently.
I have filed an affidavit in reply today, my lord. After filing the petition, Central GST conducted an inquiry and they found, my lord, there was liability till date. Out of 5 crore, 1 crore we paid, and we have made application for allowing us to make payment in installments. That is, this honorable court has directed the authorities, Central GST authorities, to consider my application. That is under consideration, my lord. I am not evading, I am here, my lord. If GST is revoked, my lord, I will be under their scanner only.
And rather government will be getting taxes and late fees or whatever interest penalties government will be getting, my lord. Yeah, I'm not shying away from payment of tax, my lord. Rather, I'm requesting this court to allow them to revoke my application, GST cancellation, so that I can conduct business regularly, my lord. It will no way prejudice the government, my lord. It will no way prejudice the government, my lord. And otherwise also, my lord, on merit also, this order
What is the difference? Those cases and your case?
same thing, my lord. They have asked them to make payment, and on payment they will revoke it. Till the date of cancellation, I have cleared my GST returns. Now, subsequently, I will make payment, and I will. In the rule 23 says, my lord, after revocation, I have to file return within 1 month. Rule 23, my lord. Rule 23 says, my lord. That is also indicated in your lordship's order, my lord. As per Rule 23. Rule 23 says, once my GST is revoked, my lord, I have to update my returns within 1 month. That is already indicated in your lordship's order. Page 45, my lord.
We'll provide them.
Yes, ma'am.
Lordship. Otherwise, our stand is only that from the inception of the registration, they haven't filed return.
But
It's in the all the year is zero return is.
So he said it's up to till the date.
My lord.
Till
Till
the date
that,
of
yeah,
cancellation.
I have filed. I have annexed the returns, and lord, they can verify, my lord, because they can always verify. I can appear before the authorities. They can verify the things, my lord.
Not verify.
If
in
they
that case,
have
we
any-
provide. If you have not paid anything, you have to pay all.
Yes, my lord. Because Rule 23 itself says, my lord, provided that all returns due for the period from the date of order of cancellation of registration till the date of order of revocation of the cancellation of registration shall be furnished by the said person within a period of 30 days from the date of order of revocation of registration. Moment my GST is revoked, I have to file all the pending returns. I have to pay things within 30 days. That is the fourth proviso to Rule 23, my lord.
No, we'll say you have said that you have paid up to the till the date
Yes,
of
yes.
revocation. What do you call it?
Cancellation.
Cancellation. But it will say that if
Till the date of cancel, I have filed my returns. Thereafter, my lord, recently Central GST has conducted an inquiry, not a Central GST, and they apprised us that there is a due of 5 crore and odd. Moment they apprised, we paid 1 crore. For remaining 4 crore, we made application for installments. That installment was not, that application was not considered. We approached this honorable court. This honorable court directed them to consider our application for installment because Act provides for payment of tax in 24 installments.
in the other case.
Another case. In that case, the inquiry was conducted by Central GST, not by State GST. So Act provides if I have pending dues, my lord, I may be allowed 24 installment for payment of dues also. Section 80 provides, my lord, if I have pending dues, if I have not been able to pay at a time, then, my lord, Act provides that 24 installment provision is there. Accordingly, this court, in other cases, directed the authorities to consider my prayer. I have bought all these things on record, my lord. In my affidavit in reply, it is there, my lord. Today I have filed the order of his honorable court is also there, my lord.
So we'll not go into it.
Yes, my lord.
We'll just say that you have to pay.
Yes, my lord.
I'll record her submission that nothing has been paid as on date.
Yes, my lord.
Yes, nothing.
And we'll
No
say
return
that
has been filed till
all the dues you have to pay.
Yes, my lord.
All right.
Lordship.
Heard Mr.
R.S.
Mr. Land Counsel for the petitioner. Is there any order of cancellation?
Yes, no, page 17, my lord.
Huh?
Page 17, and actual C.
17.
Yes, my lord, 17.
Order for cancellation of heard Mr. R.S. Misra, learned counsel for the petitioner. And also heard MS D. Learned additional senior government for the respondents. Challenge made in this writ petition is to the communication dated 21/10/2022. By no, issued by the superintendent of
Respond number 3.
Texas, respond number 3, Itanagar. No, Itanagar John Dash Roman 2, huh? Respond number 3. Whereby the registration of GST registration of the petitioner is ordered to be cancelled. Robert, where would you get the amount? There's
My lord,
nothing.
here no amount was assessed, my lord. It was a computer generated order, my lord.
Huh?
No amount was assessed. It's a computer generated order. It's as per this order, the liability is nil. It is a computer generated order, my lord. Even does not contain any reason also. And it's all self-contradictory.
List.
No, this is auto-generated, lordship.
And prayed for revocation, prayed for a direction to revoke the cancellation of the GST registration list of petitioner is engaged in the business of execution of works contract, who is carrying the business under the name and style of MS Gabaru Infracorp Private Limited, a proprietorship concern of which the petitioner is the sole proprietor. Para 2 years checking. The petitioner is an associate registered under the provisions of Arunachal Pradesh Goods and Services Tax Act 2017, bearing registration number 12 CBG PT 5633 MIZ. It is para page 17, huh? 17, huh? GST registration. Mr. Next para, by notice dated 13/09/2022, the petitioner were directed to show cause as to why registration of the petitioner shall not be cancelled for the reason within inverted comma auto-generated details of inward supplies for period from 13/09/2022 to 20/09/2022. Inverted, close inverted. Yes. The petitioner was also further asked to file returns within 1 week to avoid cancellation of the registration and to furnish a reply to the pursuits, furnish reply to the so-called notice. With the direction to appear on 20/09/2024. And thereby suspended the registration of the petition with effect from 13/09/2022. Next paragraph. You have furnished a so cause.
Reply I have not furnished, my lord.
You have not.
Reason I have given, my lord. Page 6, I have given the reasons. My lord.
Why you have?
Because I was not technically equipped with this GST compliances, my lord.
No, your cancellation is 13/09.
2022, my lord.
Where it is?
Page 17, my lord.
16.
16 is so cause and 17 is the order.
17 is
the order of
21.
21/10/2022, my lord.
Determines the amount payable and
After the so cause
After-
notice, 1 month, after 1 month, 10 days, it was cancelled.
Oh, this is the applicant's difference. Mr. Thereafter, the GST registration being so and so, that's same 12 so and so of the petitioner has been cancelled as the petitioner has failed to furnish reply to the so-called notice issued to him. The so-called notice dated 13/09/2022. Mr. R.S. Mr. Learned Counsel by the petitioner submits that the yes, and then present the order of the coordinate bench of this court passed on 29/09/2022 in WPC number 6232/2020. Within bracket, what's the name of this? 6232? 6232?
6232, my lord. Page 1, WG resort.
Page
1 of the compilation, my lord. My lord.
29, right?
29/9/2022, my lord.
No. And
The lordship's order is at page 45, my lord.
in the case of within bracket, MSWG Resorts within bracket Assam Private Limited versus Union of India and others. It covers the case of the petitioner. As the facts and issues are similar. Therefore, he submits that similar relief may be granted to the petitioner. MSG at Learned, additional senior government advocate. While agreeing to the effect that the above order passed by the coronal bench covers the case of the petitioner, submits that there is a slight difference in the facts as the petitioner has failed to reply, they respond to the so cause, and the records indicates that no dues has been, no tax has been paid till the cancellation of the GST registration.
No return has been filed till.
Sorry, no return, huh?
Yes, sir.
No return has been filed. Mr. Mr. However, submits that the petitioner has already filed the up-to-date, I filed the return and paid the tax amount due along with the outstanding statutory dues as per Rule 23 of GST Rules 2017. Till the cancellation of, you have paid, you have said.
I filed returns till the date of cancellation.
Till the
cancellation. I filed
cancellation,
returns,
as per 23.
As per Rule 23.
As per 23.
23, my lord. Till the date of, not beyond that, my lord. Till the cancellation I filed.
Till the
Beyond
date
that
of
is liability, my lord.
cancellation. Please stop. Next paragraph. Having considered the submissions and considering that the grievances, submissions of learned counsel for the parties and on the perusal of the order dated 29/09/2022 passed in WPC Supra, and considering that the grievance raised in this writ petition is for a direction to revoke, or the direction to revoke the cancellation of the GST registration and on payment of the tax amount due to the petitioner, and also coupled with the fact that the order dated 29/09/2022 would cover the case of the petitioner, this writ petition is disposed of by directing the respondent authorities to restore the GST registration of the petitioner on filing the return along with deposit of statutory dues by the petitioner in accordance with the applicable rules. It is made clear that, the revocation of the cancellation of GST registration shall be carried out as expeditiously as possible, but not later than 25 days 20 days from today. And the respondent number 3 shall intimate the petitioner as regards the outstanding statutory dues as payable so as to enable the petitioner to file return and make necessary deposits, if any. It is made clear that this benefit, the similar benefits is granted to the petitioner subject to the payment of all the dues, pending dues, either including prior to cancellation and thereafter. The representative disposal with the above right. Because it shows that there is nothing. You have not paid. And she is also coming.
They can verify. Yes, my lord, they can verify. If you are available in the portal, my lord, they can verify.
Unless they pay,
Yes.
you don't revoke it.
Yes, my lord, yes. It is in the order only. Lordship was indicated. Deeply obliged, my lord.
Obliged.
Huh? 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 He was there. He was there.
Yes.
In the first half. Why sudden health issues?
Tomorrow I am having case in other court. That's tomorrow.
Day after tomorrow. My lord, can we make an endeavor on Friday?
Friday.
Day after tomorrow. Day after? Three.
Friday we'll see, but we
Malad,
cannot say.
Malad, I'll only take 10 minutes in this case.
No, no, we have
Thursday.
not, you've not heard him also.
Malad, on third, but my lord, I request for accommodation through BC in the worst case where
No, BC is difficult. BC is very difficult.
I'll make an endeavor to come.
The way fix the consent of all the parties for two. It's seriously a health issue.
Yes.
Okay. Mr.
My lord, just I'm trying to figure out this.
Heard Mr. Empertin, learned senior counsel
21st.
assisted by Mr. KW, learned counsel for the petitioner.
22. Sir, 22 free.
And also heard Mr. T.T. Tara, learned counsel for the respond number 7.
6 in the 95, 7
We'll
in
say same orders.
7.
6 and 7. We'll
6
say
and
6 and 7.
Therefore,
It's the next para.
8 and 9.
Although 18-9
8 and 9 is by
and 8 Mr. So for 8 and 9. Huh? Next para. Although the method is fixed for
Tuesday.
hearing at 2 p.m. on the consent of the learned counsel for the parties, Mr. Wairam, learned state counsel, submits that Mr. Arisnabam, learned additional advocate general, who is appearing on behalf of the state, has suddenly has got sudden health issues. Therefore, had to leave the and had to leave the court premises. Praise for adjournment of the matter. Mr. Praise allowed. Mr. Has agreed to be learned counsel to the parties. When? List this matter on.
This, the 23rd would be
23rd. 23rd, 07.
Yes.
07, 2024. 27, 25, sorry. Okay.
Let it be
And
there.
till that, interim will continue.
Interim order shall continue.
No.
Neither you are benefiting nor he. Because the government is running.
I have done for 2 months. Thereafter, the interim order came.
Hopefully you have received the payment.
That is not beyond my instruction.
It's okay.
Gratefully.
Yes, obligation. Yes.
Your Lordship, I'm appearing on behalf of OMO, the learned counsel for the petitioner.
Hmm.
Your Lordship, counter affidavit for respondent number 1, 2, 3, and 4 is still awaited.
Which for 1, 2, 3, 4? Hmm? Which for 1, 2, 3, 4?
My senior, Mr. R.C.K.
Hmm.
Responding number 1 and 2.
Then
Well, my lordship, I'm appearing behalf of Peter Fox. I'm appearing respondent number 5, 6, 7, and 8.
heard Mr. So-and-so learned counsel for the petitioner. It is noticed that the affidavit on behalf of respondent number 5, 6, 7, and 8 has been filed. Is filed, huh? Is filed, Mr. On the prayer of next prayer, on the prayer of learned counsel, Mr. So-and-so, huh? For the respondents. Further 3 weeks time is granted to file their respective affidavits.
Here, the respondent was like.
Heard Mr. B.P. learned counsel for the petition and Mr. So-and-so learned counsel appearing for on behalf of Mr. R.C.K. for respondents. Respondents
1, 2.
Respondent Information Commission.
Yes, ma'am.
1 and 2. Next para. It is, the office note indicates that records is yet to be received. Please register to send reminders. This after 4 weeks.
Obligation.
May your lordship.
Yes.
Your lordship, we have to file affidavit in reply for respondent number 2 and 4 in item number 20. So for that, we didn't receive any instruction, and in item number 21, we have to file affidavit opposition for respondent number 6. That is ready, but we
On
need
the
some.
prayer of MS T. Somo, learned counsel for the petitioner. List this matter after 3 weeks so as to enable her to file affidavit in reply.
Yes, Your Lordship. In item number 20, respond number 2 and 4. In item number 21, respond number 6.
No, all reply on both.
Yes.
Reply.
Obligation.
List after 3 weeks. 3 weeks or 4 weeks? 3 weeks. When it might become infructuous. What is the matter? Transfer?
Yes, ma'am. Yes, Lordship.
Huh?
Yes, Lordship. This transfer method. Here, Lordship, service upon the is still awaited.
Heard so-and-so learned counsel for the petitioner and MS K. Wang learned counsel for the learned state counsel. Award service report. In respect of respondent number
4, Your Lordship.
4.
Yes.
List after 4 weeks.
Meantime, interim may be continued.
Interim order passed earlier should continue.
Your Lordship, for respondent number 4, I may be granted some more time to file our affidavit. Your Lordship.
Affidavit. Yes. And MSS Learned Counsel for the prisoner is present. Only prior of Mr. Warrior of Learned Counsel for the Learned State Council. Further 3 weeks time is granted to file affidavit.
Your Lordship, there is
Interim order passed the election continue.
Congratulations. Here we have filed our affidavit, Your Lordship. We have filed our affidavit, Your Lordship.
You have filed?
Yes, Your Lordship.
Office note dated. No. Office note dated 27/06/25 indicates that neither ID card nor answer notice is received. In respect of respondent number 4, non-appears by the prisoner of the home. That will be the non-appears by the prisoner. Mr. Warrior Ramlan State Council is granted 3 weeks time to file affidavit.
We have already filed, Your Lordship.
It means that he has already filed the affidavit on behalf of the state response. This after 3 weeks.
Congratulations.
Lordship, may I? Lordship, I am for the petitioner.
Sir, huh?
I'd like to withdraw this writ petition, Your Honor.
Is it? Mr. So learned counsel for the petitioner submits that he has an instruction to withdraw this writ petition.
Yes, we do understand.
MS K. Wang Mulan District Council is present. Prayers allowed. Prayer for withdrawal is accepted. Mr. Accordingly, writ petition stands dismissed on withdrawal.
Hello.
My Lordship. Lordship, service against respondent number 3 is complete and service against respondent number 3 is complete and respondent number 2 filed affidavit.
And Mr. Swenson learned counsel for the petition. Pleadings are complete.
No, Lordship. Respondent number 1 and 3 yet to file affidavit, Lordship.
Services are complete. Mr. Affidavit in opposition has been filed. Is filed on behalf. It has been filed on behalf of respondent number 2. This for admission after 2 weeks, 3 weeks.
Congratulations.
Why did I'm saying so? State Council. Nobody's there.
Nobody. On the last occasion also, none appeared.
None appears for the petitioner on call. Mr. N. Ratan, Learned Additional Advocate General is present. Respondent is present. Next para, it is noticed that on 24/04/2025, when the matter was listed, the petitioner was the non-appears, non-appeared on behalf of the petitioner, and today also and remains absent even today. Mr. Considering above, it appears that the petitioner is no longer interested to pursue the matter. The writ petition is dismissed for non-prosecution.
Obliged, madam.